Hello guys, hope you're doing great. So today we'll try to understand the new changes that has been made in BNSS and what has already been repealed in CrPC. So as you know that the BNSS has come into force in 2023 and it has replaced CrPC 1973. Some notable changes has been done and which is visible before your screen. Notes of the same will be shared in your note section, or you may get it from into legal world, any of the into legal group, right? So the new thing that is introduced in a BNSS is EFIR. So now you can obviously don't have to visit a police station now. You can make an FIR through police portal itself. You can do it online, and same will be recorded, and you'll be informed about the process of charge sheet. You'll informed about closing of the cases. So everything will be informed to you. Earlier, that was not the picture, right? There is compulsory recording of the statement of victim in the case of sexual offenses, such as in the case of rape, sexual harassment. Police will record the case, and they record the videos of the victim, and they'll make the statement in the court, and that will be admissible. Earlier, that was not. I mean, see what happens that when a person visit the court or person visit the police station, the statement gets changed, or police make certain changes due to the the influence of the power or whatever it is. Those changes won't be seen in according to the new CrPC, because the statement will be recorded, and that will be the same will be presented before the magistrate. Also, as I said that information about the charge sheet and the process of investigation will be shared to the victim. I- Victim will also get enhanced protection, which means that they will also get victim protection scheme, which will protect the victim from any uh, assault in the case. Also, forensic science has been given some important in this BNSS, and same has been taken well. So obviously now the investigation has become more Sherlock Holmes friendly. It has become more user friendly, because you may register FIR through a portal also, to online portal also, and total pardoning cases which was there before, total pardoning has been abolished. So a president or a governor cannot pardon the accused, or let's say the guilty person, right? So that is there. Important feature that you can see in your screen is that now BNSS has 351 sections instead of 528 sections that was there in the CrPC. 160 section has either been changed, amended, substituted, and 9 new section has been introduced, and 9 has been repealed. So that was a brief about BNSS. Now we'll see the section that has been changed, or the section that has been introduced. Such as you see, earlier there was no record, audio video electronic means was not there in CrPC. Now that's there. Electronic communication was not there. However, the definition of victim has not been improvised. The definition of investigation has not been improvised. Earlier, it was in section 21H, and now it is in section 21L. Now you see a very major and important change, that is change in the structure of judges. Earlier, you used to read that there is judicial magistrate third class, metropolitan magistrate, assistant session judge, and session judge. Now the same has been changed to magistrate second class, magistrate first class, third class has been removed, and magistrate first class may have chief judicial magistrate and additional chief judicial magistrate. The bracket in which the fine can be imposed by magistrate first class is that from 10K to 15K, and 5K to 10K is magistrate second class. Session judge, which comes with additional session judge and executive magistrate. So this is the new new thing that you will see in BNSS. Now, for the first time, Directorate of Prosecution has been introduced, and that we'll see in section 20 of BNSS. So there are three category here: Director of Prosecution, Deputy Director of Prosecution, and Assistant Director of Prosecution. So, Director of Prosecution can impose a penalty for more than 10 years. From 7 to 10 years is a charge of that Deputy Director, and its additional Director of Prosecution can impose a penalty of less than 7 years. Right. Now, one very important thing that earlier police can arrest anyone, right, at any time. I mean, excluding women, police can arrest anyone anytime. Now, 60 plus men or women, they can't be arrested unless and until the permission of the same has been received from police officer not below the rank of DSP. That's there in the section 35, clause 7, and also the right of aged and infirm person has further been protected under section 179, which says that if the person is of acute illness, if the old person is of acute illness, and if he is a witness to some case, police has to visit their residence and not call them upon the police station. So that new changes has been done. Now, a major changes has also been done under section 37 clause B, which introduces that there shall be one designated police officer in every district and at every police station, right? And ASI, Assistant Sub Inspector, shall be responsible for maintaining and giving information to general public about detail of arrested person. So that is a very interesting thing that now, whosoever is the arrested person, the information about the same will be shared on the notice board of police station. So I mean, human right violation and say something like that will be checked, because police now have to display whosoever they are arresting, and not only that, they have to maintain a record list. So that is something new, isn't it? While you read this, if you get something new that has been introduced in CrPC, do let me know. And obviously, I'll try to cover that as well. However, this lecture is not. This is not the end of the lecture. Some changes have also been done in section 40 of BNSS. What's that? That is about arrest by a private person. Right now, within 6 hours of arrest, a private person has to produce that person before police station. Arrested person shall be produced before police station within 6 hours of arrest. So that is not only the new thing, but it is also that, I mean, Constitution provides you the right that you cannot be arrested by anyone, and then CrPC has it that if private person thinks that the person can be menace to the law and order, the person can be arrested. But now that is not there. That is, and that has been protected under section 40 of BNSS. Now, one thing that I am concerned of is section 43 clause 3. Section 43 clause 3 says about handcuffing, right? Section 43 clause 3 says about handcuffing. So as as you can see in the offense, that such other category: escape from custody, habitual or repeated offender, heinous offenses, organized crimes, terrorist, right? Crimes and illegal prosecution of law. So these are, in these particular cases, a person can be handcuffed, and that you probably know, that is Sunil Batra versus Delhi administration and Prem Shankar Shukla versus Delhi administration. Supreme Court has abolished the practice of handcuffing, and now that is in the practice. So maybe that, see, the habitual offender or escaped offender, that they need to be the legislature thought that, law commission thought that they in such category handcuffing can be granted, because they can be menace to law and order. What do you think? If you think otherwise, do let me know through the comment box. or you may drop us a message, or you may tag us into legal world and make a comment. Now section 51 subclause 3. Section 51 subclause 3 talks about medical practitioner, right? So medical practitioner has to forward the information, the examination report, to AOI, investigating officer, without any delay. They have to do it ASAP, right? Additional medical examination of arrested person in police custody is specifically included in section 53. So that being said, now BNSS is more technologically equipped, more technologically sound, in the era where most of the offences are done through the process of technology, isn't it? Now the court can issue someone in electronic form as well, with obviously the seal of court and digital signature, right? Section 63, that is there in section 63. Now section 70 allows for service of someone through electronic means, and section 64 says that police has to maintain a register where they will keep a record, keep the address, email, phone number of person who is summoned. Now we'll talk about proclaimed offender under section 84, right? Proclaimed offender under section 84. So earlier what used to happen, that I mean, proclaimed offender was not a common term, and even if in the heinous offences such as rape, trafficking, the proclaimed offender doesn't cover this category. Now a significant change has been brought, and under section 84 subclause 4, it has been reduced that the offences which has more than 10 years of imprisonment or life imprisonment, or that imprisonment, if someone has committed any offence which is punishable for more than 10 years, such offender will be called proclaimed offender, right? I hope you are able to get the concept. Now section 94. Section 94 basically talks about electronic communication, right? Or WhatsApp communication, or whatever media it is, all of it will be covered under section 94. Section 105 is specifically talk about videography process of search and seizure. So if let's say police is coming in your house and they are asking for your house to be searched, they have to record the video of it. I mean, I was thinking that when law commission has asked everyone to make a suggestion, back then I made a suggestion that whenever police is visiting the home, they shall record it instead of calling someone from the neighborhood, or someone of a reputed some reputed person from anywhere, and see the situation. What police should do is that they should record entire scenario and project it before the court. I should have mentioned that instead of just recording it, they should live record it, and that should be stored. The data of live recording, that should be stored in the house of magistrate, so that, I mean, that's if it is not necessary for magistrate to watch out, but let's say if there is any lacuna, that should be recorded in the house of magistrate. And because we could trust the magistrate, judicial magistrate obviously, so we could trust the magistrate, whenever required we could advocate and ask for such recordings. So that would have been a different plethora. I believe that in the next upcoming amendment, this particular clause will be amended and will be changed, that there should be live recording instead of just recording, because live recording will add one more impact. What do you think? Get in touch with me through comment box. Right, that's it for this video. We'll be recording another video that will they will talk about detail process of detention, zero FIR, search and perpetual property, and so on and so forth. This video is going to be long, so we have divided into two parts. One part we have delivered, and another part we will deliver in some time, maybe in 2-3 days. Thank you for your time.